actual statement and the wording of it. What the chairman was doing as any head of a constitutional institution, in the context in which the country was indicating to the country in the spirit of transparency and accountability that in these unique circumstances, the timelines, the political situation, we were facing challenges. The Commission was doing its best to deliver within a particular timeline and warning political players and others that they must abide by the rule of law and we must operate within the law for us to be able to deliver a credible election. That does not suggest in any way that he was not sure about preparedness. If you look at that statement, it is very clear that the chairman made it very clear that the Commission was prepared for the elections, but there were challenges outside the Commission. As the court has said, elections is a process, and that process involves multiple players. And the communication was to those multiple players that they must also play their role to deliver an election. It has happened to the judiciary, for example, when there are attacks on judges from outside for doing their job. We cannot fault the Chief Justice for standing up and saying, we cannot accept this, or this attacking judges is a challenge, we cannot accept it. That is what the chairman was demonstrating, that there were challenges, but the Commission will remain independent and in charge and deliver an election. Now, on 25th, the second statement is on 25th of October 2017, the day before the election. The statement then, the chairman indicated that at that point, he was convinced that the Commission was ready to carry out an election on 26th of October. He repeated those sentiments on 30th of October when he was delivering his speech before the declaration. The question you might ask is what changed? Indeed, in his statement of 30th, which is in the public, and even on the one of 25th, he made it very clear that certain things had changed. First, on the political environment, the chairman had interacted with the main political players whose supporters were probably the most agitated. That is His Excellency the President and Right Honorable Raila Odinga. He had met both of them, engaged them as he should as an arbiter, and they had indicated their willingness to play within the rules and to encourage their supporters to ensure that they play by the rules. And you would have heard those political players talking about the right to vote and the right not to vote, so that those who wanted to vote should be allowed to vote and those who didn't want to vote should be allowed to stay home. That is one of the things that changed. Secondly, there was a security question. The security question related to parts of the places where elections eventually didn't take place, but generally. On that respect, as I said, this process has other players who support the Commission. Security is a function of the National Police Service and other agencies. So what had changed by that time, and this is all in the affidavit of the chairman, is that he had received assurances from the Independent Office of the Inspector General and other agencies that they were confident they had put in place sufficient security measures to secure the election and the officials and to allow people to vote. So that had also changed. Those assurances were not there as of 18th of October 2017. Thirdly, there were some questions about the internal organization that the chairman had alluded to, that there had also been a change in that respect. That change, as is publicly known, was that there was a project team that was carrying out this election, and that some of the officers, although they had done nothing provably wrong, decided for the sake of the country to step aside during that period to allow the election to go on. So in light of those changes, the chairman was confident, and he remains confident, that the election was carried out in the right environment, except the places where it didn't take place, and that the election that was carried out was fair and credible, and that the declaration that was made on 30th of October 2017 declaring Honorable Uhuru Kenyatta as president-elect and William Ruto as deputy president-elect is valid. I hope that I have explained the chain of events relating to those statements, and there is nothing wrong if circumstances change for a public official to admit and to move forward with what needs to be done. But as I said, I think what those statements also demonstrate the transparency and accountability of the institution. Finally, on that point, I think the assessment of the credibility of an election is a post-event. There could be questions before, and it's a process. But the real time you can do a proper assessment is post the polling event. And that is indeed what this court is doing. So we cannot rely primarily on prior events to determine the credibility of the election. Allow me then to move to the question of universal suffrage. I think there are a couple of questions. Part of what I'm going to deal with was partly touched on by my learned colleague, Mr. Kamau Karori. Three main issues: the question of postponement of elections and its effect on Article 38 rights, as well as whether the final declaration was valid. Let me start with the first question, the effect of postponement on Article 38 rights. You have been urged by the petitioners to find that because of the postponement, and I repeat postponement, there was never cancellation or abandonment of those elections. It was postponed, and the Commission and the chairman remain in a mode of assessment to determine when it is practicable in terms of Article 55B to carry out those elections. Now, the context of postponing that election, I think, has been laid out. But you will remember that, one, as Mr. Karori explained, the Commission put in place the basic infrastructure to deliver that election in those constituencies. All election materials were delivered to those constituencies, and they are still available for the election. Officials were available if they were not prevented to deliver the election. So that part the Commission did. You will also recall, my lords, my ladies, that the Commission made every attempt to still give those who did not vote on 26th a chance to vote within the 60-day window. That is why, despite the logistical nightmare, the Commission postponed the elections in those 27 constituencies and in Turkana and Fafi to 28. The purpose was to allow those people a chance to vote within the 60-day period. Unfortunately, while it was possible in Turkana Central and Fafi, it was not possible in the other constituencies. How does that affect Article 38 rights? In our submission, in fact, Section 55B, its primary purpose was to preserve Article 38 rights. Unlike what you've been urged by the petitioners, it is not a restriction to Article 38 rights. It is an enabler of 38 rights. In this sense, if this had happened in 2015, before the amendments in 2016, the only thing that was possible before was an adjournment for a short period of time. For example, polling started late. Under Regulation 64 of the General Regulations, the presiding officer, in consultation with the returning officer, could adjourn polling or could transfer the polling to another polling station. But there was no possibility that you could postpone elections for 2 days or longer. So in that sense, and I believe that was the basis that the Joint Committee introduced 55B to protect Article 38 rights, so that if on the day of election, and the reasons are prescribed, if on the day of the election you cannot vote because of a natural disaster or the real threat of breach of peace or actual breach of peace or other emergencies or major electoral malpractice, for example, if all the ballot boxes have been destroyed the day before, which is an offense and a malpractice, then you will be given another chance to participate. That is the essence of 55B. So to suggest that 55B is a restriction in the context of Article 25 of the Constitution, and that we should be asking the question whether it is a reasonable restriction, is to lead the court in the wrong direction. There is no restriction that Article 55B introduces, and there is therefore no reason or no justification for the court to inquire into the reasonableness of the action of the Commission in that sense. So Article 38 rights are preserved by 55B. We face a more difficult situation now, but as I said, Article 38 rights had been preserved from 26th to 28th. Unfortunately, in these unique circumstances, it was not possible, but the law only allows a postponement, and the Commission remains in that position to see what to do. To buttress that argument that it's an Article 38 protection, you will see the structure of 55B. If you go to 55B3, though in the current circumstances a declaration was possible, 55B also foresees that it's possible that a declaration might not be possible if the elections are postponed. Because if the elections are postponed, assuming there were not 27 constituencies, there were 100, and we have a mix of voting, and we did not meet the threshold of 25 counties, 25%, for example. Section 55B foresees that the Commission cannot call for a return and the chairman cannot make a declaration. What does that mean? It means that if the people who have not voted are substantial, then Section 55B says you cannot call that election because those people are substantial enough to change the result, and therefore Article 38 rights should be protected. So if you go through that sequence, you will see that the outcome is not just one way. The outcome is not just a declaration of a president-elect. The outcome could be the opposite. And that is why we argue that it is indeed an Article 38 rights protection. Let me move to the other question about constituencies, voting in each constituency. When elections are postponed under Section 55B, as we have emphasized again and again, it is a postponement, it is not a cancellation. When elections are postponed in that way, there is a continuing election that is expected to take place. The only reason you can make a declaration is if you are satisfied that the numbers are there. But it's a continuing election. So the election was planned and will eventually be delivered in all the constituencies. It is our submission that the court cannot insist, in light particularly of Section 55B, which the petitioners have admitted is proper and constitutional, and even if they didn't admit is proper and constitutional because it's anchored in Article 82D as the proper law anchored in the Constitution to guide elections. In that case, if we move in that direction, then you will see that the Constitution contemplates a continuing, read with 55B, a continuing election that will happen in all the constituencies. Then the question would be, if it hasn't happened, can you declare? As I've said, 55B allows that declaration. But if you look at Article 138.4, it also suggests to us that, in fact, it is possible to declare a president-elect and to sustain that declaration even if, in the circumstances recognized by law, elections have not taken place. Why do I say that? Article 138.2 is about 5 lines away from Article 138.4. So if you look at it, you can see it together. So Article 138.2 says elections shall be held in each constituency. 138.4 then says the threshold for a declaration is above 50% of valid votes cast and 25% of valid votes cast in more than half of the counties. If the framers of the Constitution intended to have the threshold to be the constituency, just 4 lines below, it is our submission they would have introduced a threshold for constituencies to be a determinant of whether someone can be declared president-elect or not. But because they left it out, it is required that elections shall be carried out, but it is not a threshold for you to meet the constituency requirement. It is our submission that then the requirement for constituency is not a determinant of whether or not a presidential election is valid or not. And as I've said, the framers of the Constitution would have provided us with a solution if that was the intention. I think I will wrap up and allow Mr. Muhoro some time to do a closing for us. But in wrapping up, I want to point out one other allegation that has been made related to postponement, but it's not a postponement issue. You will see in the petition that the petitioners have alleged that in certain places, including Kibra, Olympic Primary Polling Center, the polling stations were moved illegally, according to them. And on that basis, they impeach the results relating to those polling stations, and of course, as an irregularity that should affect the overall election. That allegation is not true and can be answered in the following ways. Regulation 64 of the Election General Regulations, which I indicated came earlier than 64A, which relates to postponement, allows presiding officers, in consultation with the returning officer to adjourn polling, not the election, to adjourn polling to a later time or to transfer a polling station to another polling station in cases where, for example, the polling station is not accessible, or there is a problem with the polling station and there is a nearby polling station where they can do that. What Regulation 64 requires is that if that happens, a notice should be given to the voters in that place as to the new polling station. In all the cases that the petitioners have pointed to, including Kibra, the notice was given. And in Kibra and other places, I think everyone saw what happened. The entrance to the polling station was barricaded. In fact, I think it was welded at some point. And it was therefore not possible for the presiding officers to carry out elections in that place. But there were nearby places. What they then do, as allowed under Regulation 64, and there's an affidavit from the Kibra returning officer, was to consult the returning officer to find alternatives nearby where these people could vote. And they gave notice, pinned notices all over to say, we have transferred these polling stations to this other center because it was not possible. In those circumstances, all that will be then done is the hours lost for transferring the polling station will be recovered when voting resumes. Now, it can be a transfer or an adjournment in the same station. For example, polling material are late, and therefore the presiding officer adjourns the start of the polling to, let's say, 4 o'clock in the evening. What is required by the regulation is then to compensate for that time. So I think it's important to recognize the area where adjournments happened and the regulation governing adjournments, as opposed to where postponement happened and the law and regulations that govern postponement. My Lord Chief Justice, my lords, my ladies, unless you have any questions, I would like to rest there and allow Mr. Muhoro to address, I believe, the question of independence of the Commission, as well as do a closing.
Thank you, Mr. Sisule.
Thank you, my Lord Chief Justice.
My Lord Chief Justice, your fellow judges, I believe after such incisive submissions from young minds,
We have nothing useful to add.
no, a grizzly like me will have to just sparkle a bit and sit down. My lords, we have a little issues of housekeeping. I just want to tell you that our issues are contained in our responses for both petitions. The issues are there. The issues that you had said that we had put them in our submission, in our responses, for both first and second responding together. Secondly, my lords, we had intended to play tips. I even actually asked for equipment, but because of the time, I just want to refer you to the affidavit of Mr. Andrew Limo and the certificate therein and the CD contained therein. Those have been served on all the parties, and they show the areas, some of the scenes that defined the decision to postpone elections in certain areas in this country. That's very important to note. Thirdly, my lords, I'm urging you as a court to take cognizance of Article 26, the right to life. We are all talking about the Constitution today and in this petition because of we are alive. I can assure you, if we die, the first thing you would want to remove is your name from the register. My Lord, when the commission and the chairman was making the decisions that they made, they had to take into account the overall effect of their decisions. If they had strictly followed the law, after reassurance that the police would provide extra security, more boots would have been placed on the ground, and from what was going on, my lords, let's not bury our heads under the sand. Body bags would have come. Death would have followed. That is the decision the commission faced. Some decisions which a lot of people cannot encompass, very difficult decisions, were placed on the head of the chairman and his commission. Decisions that are life and matter issues. Decisions that are beyond an election. That is what was placed on them. And that's why I urge this court to look at the CDs. From there, you'll see how difficult it was. Now, not too long ago, I was before Justice Odunga. And he said, judges don't go to heaven on Friday and come back to earth on Monday. You are all living with us. You're all part of us. And whatever was happening in front of everybody's eyes. And to expect otherwise from the commission would be very unfair. And more so from the chairman, it would be extremely unfair. My Lord, I urge you to apply the test that any reasonable man would apply. Anybody who was in Kenya at that time knows what happened and would not have expected any more reasonableness. The test was it reasonable? Was the chairman reasonable? Was the commission reasonable? The answer is they were under the circumstances. We watched on television as presiding officers, ladies were assaulted in certain towns, in training. People's houses were burned, people were raped. And the commission did the only prudent thing under 55B. My lords, I also urge you to look at the statements of the chairman made to Kenyans on the 18th, 25th, and 30th, and read them collectively. The chairman progressed from despair to hope in those statements. Any reasonable man in his shoes at that time, without assurances from other people, would have doubted whether they could live an election. The circumstances were dire. But after he talked to the people leading the bigger formations, he then felt reassured, and then certain actions were taken, tough actions were taken. By 25th, he was ready for that election. By 30th, he told you he was extremely satisfied, and they're all working as a group. In fact, if people do not agree, if people disagree, if people are always agreeing, then there's something wrong. Even in this court, you give majority decisions and minority decisions. That does not say you disagree. Tomorrow you'll change in what you believe. It's not that you have permanent sight. So, my lords, To judge Chairman Chebukati different from how you judge any other man is manifestly unfair. If I was in this position, I would have done the same thing. I'm sure many of us would have done the same thing. You must remember that our social media and our media systems and our people have become extremely suspicious of one another, to the extent that they can malign people. Now, my lords, on the issue of your direction, 1st of September, your judgment, you say you annulled the election of the 8th and ordered a fresh election within 60 days. The understanding, my understanding, my client's understanding of that is that you ordered a rematch between the 8 players. You did not order, you only ordered the 100-meter dash. You did not order for heats. First round, second round, semifinals, quarterfinals, you didn't order for that. You ordered for a rematch. Because only a rematch could fit within the 60 days. Everything else is just wishful thinking. You could not have nominations. If you start the nomination process and all those, the parties where political party tribunals listening to whether this party is properly nominated, the whole process would have taken over 120 days. And that's up to the day of nomination. And then you'd have the registers and the examination of the registers. There would have been a hell of a lot of things to do. Section 2 also. That is my humble submission, that you ordered a rematch. Not, you didn't start from hits coming up. My lords, the petitioners are actually asking, that's my humble submission, are asking this court to bury its head your heads in the sand and not to take into account what is around you. You're members of this society, and you have seen what has happened. My lords, the order was clear, elections in 60 days. Some parties, some people went out of their way to frustrate that 60 days. Frustrate your order. My client, the chairman and the commission were working under very difficult circumstances. Working under what was possibly one of the most well-schemed sabotage schemes. Up to the last day, they were still struggling to hang on. And there were people determined that this election will not take place, contrary to your orders. My lords, I'm thus urging you to dismiss the petitions and to listen to the first and second respondents and to empathize with the state of things during that period. But finally, my lords, despite all that, my clients, the chairman, and the IBC delivered a fair, credible, and verifiable election. In fact, the best ever. If we were to be graded worldwide, I believe we'll be #1 now, thanks to your directions. Thank you, my lords. Oh, I would like to lend my 15 minutes to one of my former colleagues, Mr. Ngati.
You didn't mention the tapes.
Okay? Oh, yes, there's a book that Lucy had mentioned, and some person watching us live who we don't know. He's known as Mr. Anthony Kamau. He must be some loyal citizen. has sent a message that he has a soft copy of that book, and Lucy Kambuni undertakes to forward it to the judges.
And to our colleagues.
And to all the colleagues. And thank you to that fellow out there.
Please thank him for us.
We have the tapes, fellows, but we don't have the time to differentiate. We're just urging you to watch them.
Okay.
I want to lend my pen.
Sorry? You said what? You
I
are
want to lend my remaining, I don't know, you're still running it, 15 minutes.
15 minutes?
Yes, to Mr. Ngatia.
We will consider whether to give him those minutes tomorrow, because we want to adjourn at this stage.
Yeah, but
the 15 minutes will be credited to us.
That's what I said.
yes, my lord, before the court adjourns, I am listening to my colleagues, especially representing the first respondent, and wondering whether the praise they are showering themselves with is really true, because they are in continuing breach of the order that the court issued this morning of allowing us access to scrutinize Form 34As and Bs. Pursuant to that order, IEBC, I do not know by what authority, created some rules affecting us in the access. And they say there is a preamble referring to the decision of the court today. And then they say the following rules shall apply. Each party shall be allowed only 7 agents, which is correct. The agents must be identified by their original Kenya identity cards and must sign the attendance register to access the room or storage area of Form 34A, B, and C, respectively. No document, paper, or other material shall be allowed in the storage room, and a security check for this purpose shall be conducted on each and every agent accessing the said room. 4, IEBC shall provide to the agents requisite writing material, that is a pen and writing paper to each agent. All documents from 34A, 34B, and C shall at all times be under the custody and control of IEBC. There shall be strict compliance with the order of the Supreme Court given or issued today, the 15th November 2017. Now, I recall, my Lord, the Chief Justice saying that indeed we have that access and we should be free to make photocopies of the forms that would interest us or take pictures of the same. Now, they have erected roadblocks. Our representatives cannot carry any item on them, including their own pens or paper. In fact, some of them had details of the forms we had complained that they